A very great Monday. This we're delighted to have you join us here on ITV. This is Law and You. We're broadcasting live from Benin City, Nigeria. I am Uyi Admofwewe. This week, incidentally, we're turning our attention altogether to something different. However, one topic that Nigerians can readily relate with, because there are several questions along that line. So hopefully, in the course of this week's program, all efforts will be made to ensure that those questions, at least a good number of them, are answered. Let's look at corruption, for example. In the middle of that conversation, one of the things you hear is financial crimes. First, what constitutes financial crime? What makes a financial crime financial crime? All right, then we're going to look at it from the angle of the law. So this week's edition of the program is going to consider financial crimes in the eye of the law. My guest, obviously, is a lawyer, and he will help us shed light on some of the topical elements, or if you will, very core elements of financial crimes. Douglas Ogbakwa.
Pleasure to be here.
Yes. Let's first of all begin from the song about financial crimes, because it will appear everybody now knows a thing about financial crimes. But sometimes we're also afraid that it could be nothing more than an assumption or speculation. Worse still, what exactly are the, if you will, ingredients of a financial crime?
Well, a financial crime would be any crime in which there is first of all financial transaction,
Okay.
and in which one of the parties to that transaction has done something that is untoward. Before the coming to democracy in 1999, there were no particular legislations criminalizing financial crimes, and there were no special institutions that superintended over the issue. The best we had was the Special Fraud Investigation Unit of the Nigerian Police in Leviton Avenue, Ikoyi, Lagos. But in 1999, when Olusegun Obasanjo came in as president, the first thing he did was to ensure that there was a promulgation of the ICPC Act of 1999. And thereafter, the EFCC Act was also promulgated, not too long from that. And the Code of Conduct structure was reinforced, because it was before now, it was already then in the Constitution. So right now, the issues that concerns financial crimes have even gone to a larger proportion. Now, right now, the National Assembly has created a different center for monitoring of financial transactions, which is to be a unit under the EFCC. And you note that the financial crime does not just mean stealing money or withholding someone else's money. It also means a thing like money laundering. And money laundering would mean where you take bad money, you put it in good business, and you take good money back. Do you understand? I'll give an example. For example, if someone was to do trafficking of cocaine to any country in the world, and right there abroad he makes like $100,000 US, he uses that $100,000 US to buy cars
And bring back
to Nigeria, and he makes real money and puts in the bank. That is money laundering. And that is why, for example, if an individual does any transaction that's more than 2 million naira, there's supposed to be an alert that's sent to this financial monitoring unit and would not trace the source of the funds.
I'm going to create a situation here where we have to redirect this conversation a bit.
Yeah.
You just said supposed to, when you made allusion to an ideal situation
Yes.
where obviously if a transaction shoots above the threshold
Yes.
of 2 million naira,
Yes.
so certain questions will be asked.
Yes.
I think that has been the real issue. The situation, as far as financial crimes are concerned, has really not been ideal. For instance, there's the EFCC Act of 2004.
Yeah.
To what extent, as a lawyer, in fairness to truth, would you say that act has been effective to the extent that it has been able to curtail, to a large extent, these incidents of financial crime?
The EFCC Act has done a lot to strengthen the legal regime as it affects financial crime. For example, before now, you may not be able to have interim attachment to properties. But the EFCC Act creates a scenario where the EFCC can go to a high court judge, with an ex parte motion, with documents and affidavit in support to show why a property or money that is proceeds of financial crime can, for the time being, be forfeited to the federal government. Now, the person who owes the money, who owns the money, can actually cause why the money would not now be permanently forfeited to the federal government. You understand? So that wasn't really there. And you know, there are also scenarios now that even that the Administration of Criminal Justice Act, ACGA, says that when you are charged for anything that has to do with taking someone's money or taking an institution's money, that you now have to pay restitution. That wasn't there before. Before now, when you were charged for a crime that has to do with maybe you're stealing someone's money or criminal conversion of someone's money or advance fee fraud or obtaining by false pretense, you just have to either deal with the J-term, or in some very, very ridiculous scenarios, you pay an optional fine. Like the man who was alleged to have taken police pension funds, running into billions of naira, he was given just a paltry sum to pay as optional fine. Seems like a bonanza to him, you know. But right now, the Administration of Criminal Justice Act, ACGA 2015, which is the federal legislation, by the way, it has not been domesticated in Edo State, provides that when you are charged for any crime that has to do with you taking someone else's money or an institution's money, there will be restitution. And what that means, it means that you will have to pay back that money. Apart from the fact that you are convicted, you have to pay back that money. And how do you do that? When the judgment comes, you get the judgment debt, the judgment, what's it called, the arraignment of order, the arraignment of judgment, and you go to the bailiff of court. And if you have movable or immovable property, you forfeit. And if you have money in the bank, you attach it, or you do what they call what we call it, you garnish the account, you know, so that this money will now refer to the owner of the money. So all these scenarios were not there before now. You have a very loose and legal regime in place, you know, to regulate financial crimes. But we are actually evolving from time to time. But right now, you now have a scenario like an institution like the EFCC is expanding its frontier. The EFCC has an office in Benin now. Before now, if we needed to do any EFCC matter, we have to go to Port Harcourt, have the zonal office. But the EFCC has created offices in almost, if not all states of the Federation. So that way, it's trying to create a structure, a state structure in the state of the Federation to ensure that persons can access them easily to make complaints.
Yeah, let's look at the ACJA that you just made reference to, 2015.
Yes.
One of the issues lawyers, brilliant lawyers like yourself, talked about would be the fact that it provides this window for plea bargaining.
Yeah.
For individuals or maybe institutions alleged to have been involved in certain kinds of financial crimes. Is that a blessing or a curse in the eye of the law? I mean, looking at the peculiarity of our environment.
Okay, you see, plea bargaining, it actually, like, if you do a little bit of what we call comparative analysis, it happens in other parts of the world. Yeah. So it's actually something, you know, because the reason why plea bargaining may be a blessing is this. Many people don't really understand what it takes to secure a conviction. It requires a lot of circumspect investigation, first of all. Do you understand? Most times when a conviction fails, it fails on the investigation level. Do you understand? When you have a scenario where the investigation is tardy, there are some things ordinarily you should do. You didn't do them. The judge or the lawyer in court are not magicians. You know, so sometimes people say, they just allowed this person to go, they would have collected money. It's not always like that. If the investigation is tardy, in such a manner that even the blind man will know that, this is tardy investigation, there's no magic you can do in court. Now, you talked about plea bargaining, because I need to draw the thread on why I went given such scenarios. Because to secure a conviction is not an easy thing. Now, if you put in witnesses, put the first witness, put the second witness, something may happen. The judge may be transferred to another jurisdiction. The judge may be elevated. You may have an act of God. What happens? You have to start what we call de novo.
All afresh.
Yes, and it's terrible. You don't want to know. So the suspect, you have to go to the what's it called, the dock, and take his plea afresh. It's either you apply for bail or you apply that the suspect will remain on the summer bail. You now have to start bringing the witnesses. Now at times the witnesses are dead, they have been transferred. So it's the whole lot. So when you have a scenario that someone says, okay, I am guilty. Mind you, plea bargain does not mean that you are not guilty. Once you are seen to plea bargain, you are convicted.
On the spot?
Yes. The only thing is, there will be a bargain that because you have now saved the state the stress of going to your hog, and also the stress of spending money, because this thing actually costs money. You know, at times when I go to the Federal High Court, the EFCC, they bring in lawyers, they fly in lawyers from Lagos, from Abuja. That's money, you know. So you have to stay in the hotel, toll duty allowance, you know, it's costing the state money. So the state will now say, okay, because you have returned some of this money.
Voluntarily?
Yeah, voluntarily, yes. Yeah, you know, so, and then you have also said you are guilty, you are convicted. Well, the money you are returned will be deemed to be something like, okay, you can go and sin no more. But that's not to say plea bargain does not mean that you'll be exculpated. Do you understand? What it does that it mitigates your problems. So
the penalty.
Yeah, the penalty. You know, so you might just be asked to just maybe pay some fine and you go. And so that's what plea bargaining does, and it tends to reduce the pressure on the state, because for you to say you want to plea bargain, it means that you have agreed that you're guilty. And any person that plea bargains is a convict. And of course, you know that has its own implication. So being an ex-convict, you cannot be appointed into government positions. You cannot get in. You cannot. There are some kind of convictions that you cannot even be a director in a company. You know, depends on the level. If the conviction has to do with separation of funds and all that.
So it depends on the gravity.
Yeah, the gravity of the crime and all that. You know, so it tends to give a leeway for the state to relax, because even the facility of the state when it comes to prosecution is overstretched. Do you understand? Because there are a lot of crimes going on, but very few policemen and lawyers pursuing these crimes. So sometimes what happens is that some people go scot-free, either from tardy investigation or tardy prosecution, or lack of diligent prosecution.
Apparently, you've made continuous reference to the issue of prosecution. It shows how critical it is to, as it were, the chain.
Yeah.
As far as fighting financial crimes is concerned.
Yes.
Incidentally, too, in the last couple of years, we've seen several situations, instances, perhaps more than we can count on our fingers, where the EFCC, as a forefront agency of the government fighting financial crimes in particular, has been accused of shoddy investigation. I mean, that's actually being said to be the reason they get to lose so many cases in court. We're just going to get a response to that question just immediately after this break. We urge you to stay with us on the program. Thank you for staying with us on the program. So we're talking about the EFCC having to grapple with situations where a number of Nigerians think they are not doing due diligence as far as investigation is concerned. Of course, investigation precedes going to court. What exactly are factors responsible for this? Is it possible the EFCC is overwhelmed because of maybe depth of resources to pursue these cases? Because you made clear reference a while ago to the fact that the EFCC needs money to do all of these runs, as it were, bring in lawyers, get to ensure that the process is hitch-free. I mean, it doesn't come cheap, really. What exactly is the EFCC dealing with? I don't expect it to be holding brief for the EFCC, of course, but this is one agency of government that's fighting tooth and nail against graft.
Yes. You know, there's what they say. They say sometimes you fight corruption, and then corruption fights back.
Okay.
You know, first, we must understand the fact that the people who are in the EFCC are humans, and they're not just humans; they are Nigerians. You know, so the human factor at times could come in, not in all cases. So it differs from scenario to scenario. Then, you know, investigation activities are, you know, we have to take our investigation activities very seriously in this country. I'll give a scenario. There was a case of a young boy that was found in Thames River in London some few years back. They didn't even know his name. They called the boy Adam. Now, the boy was of no significance to the British government. But because the British government takes life seriously, they spent about £1 million to find out the cause of death of that boy and where he came from. And I met a Nigerian police officer who, because of that, had to fly to the UK, all expenses paid by the British government, to help with the investigation. That is how seriously countries that know what they are doing, they take investigations. No investigation is less or more. All these media trials, You are arraigning people in court. You come and say their bail is going on. You notice that most times after those feuds of the arraignment, matters begin to die down. We should take investigation, first of all, seriously, and prosecution also very seriously. So taking investigation seriously, for example, I am of the view that every investigation that is what is sought should have a lawyer be part of it. In the United States, if an investigation starts, if it's 1 a.m. in the morning, the lawyer is there. That's what you sign to. You just get paid your inconvenience allowance. So when the lawyer gets there, let's say there's a scene, he gets there, he'll be able to advise, you do this, you do this, you do this. That is how sometimes these institutions, government, prosecution bodies lose good cases, because what a lawyer will see, you as a layman, no matter how good you are as an investigator, you will not say it. You know, so they have to infuse from the investigation process lawyers to be involved, because they will be able to advise on some steps to take based on precedents that they have come across in their legal practice. It's very important, based on precedent. For example, let's assume the EFCC is investigating a case of forgery, for example, as part of financial crimes. You have to bring the original of what is being forged.
To prove forgery?
Yes, you can't say something is forged and all you have is the forged document. Where is the original?
It's like saying somebody has a fake 15 naira note.
Yes, you bring the original 15 naira.
15 naira.
Yes, and you compare it in court and say this is the original, this is the fake. You cannot just carry the fake and say this thing is fake. Even if you have the best forensic analysis in the world, if the lawyer that knows what he's doing, all he has to do is to bring a Supreme Court authority that says that if you are doing a case of forgery and you do not tender the original, it's dead on arrival. You know, so only a lawyer that knows the sort to be able to advise, this case of forgery we are doing, where's the original of this document? Even if we cannot have the original, let us have a photocopy or a certified true copy as the case may be. You know, so these are some of the things that we'll have to put in mind so that we know how these things really work. Because these lawyers that go to court and get these people free, they are persons who have applied themselves and they know the loopholes, you understand, of these particular cases we're talking about. You know, I'll give you an example. An EFCC operative is asking questions from somebody. You did not allow him to make his statement freely. You ask him, so when you were not the director of this institution, at so date, how much was transferred to your account? Write it. The person will write it. So you moved 2 million naira from your Zenith Bank. And so did you say, I did not? Okay, write it. Now, even if the person admits everything, a brilliant lawyer will just ask that EFCC officer one simple question. And that's the end of that statement. As at the time you asked the EFCC officer, at the time that the accused was making statement, you were asking him questions. And he was asking, he would say yes. Now, the EFCC officer may not know the significance of that question. The significance of that question, or his admission that he was asking him and he was answering, is that statement was made under duress. Because the judge's rule, which has been interpreted many times by the Supreme Court, is that when you want to allow, when a suspect is making statement, you give him the statement sheet, you give him his Bible, let him write. If you are eliciting answers from him, they call it cross-examination. You are taking that statement under duress. That's the judge's rule.
Let me push you a little something very pressing here.
Yes.
Perhaps this will be a window for you to be a judge in your own cause.
Okay.
Lawyers some lawyers really have been accused of aiding and abetting alleged financial criminals in this country.
Yeah.
How much of element of truth do we have in that?
The first thing people don't understand is that the rules of professional conduct makes it professional misconduct for you not to accept briefs from a client.
Okay.
Even if you were there when the client killed the person, and you are convinced that he killed the person, one person comes to you and says, sir, I want you to be my lawyer. If you say no, I will not do it, it's professional misconduct.
So where does that leave conscience, for instance?
Your conscience is subject to the profession, because at the time you took the oath to defend and to conform to everything that has to do with
it all revolves around the whole.
When you're called to bar, you just stand and you say, I hereby, you say you are hereby called to the Nigerian bar, so to speak. You know, and when you are called to bar, before you are called to bar, there are so many, how will I put it, many things you go through, many orientation you go through. They teach you all these things in the law school.
And it gets to count in the future.
Yeah, it has to count. It has to count. You know, people that say that it's lawyers that aid, if a lawyer, for example, helps a financial crime suspect to move funds, then the lawyer should go in for it. But if I, as a lawyer, am in court defending person, how will you feel if I lose my case? Do you understand? If I'm in court defending someone, and I have, because the truth is, they'll say lawyers are liars, but that is not true itself. What lawyers do is that they apply law to facts.
Okay, talking about lawyers too, and what they do now still. I had a lawyer here just last week, and we got talking about law enforcement. And one of the issues that came up in between was the subject of frivolous applications. We've also seen that as a strong factor in the fight against graft.
Yes, I agree with you absolutely.
If you will, is it possible to, if not totally eradicate, or at least minimize?
Yeah, very well. Yeah, very well. You see, the Administration of Criminal Justice Act, for example, has made it impossible, has precluded you from filing an interlocutory appeal when a criminal prosecution is ongoing.
Okay.
Do you understand? So, whatever issue you want to situate at that interlocutory stage, you have to wait till the final judgment to file your final appeal in respect of the matter. So, that law has, in a way, has removed those issues of filing frivolous application, because what they will do is that they will just file frivolous application to serve as a clog in the wheel of progress. Now, I have to tell you this, that whether or not a frivolous application will go through has to do with the mien of the judge. And I say this as someone who have appeared before many judges all around Nigeria. I can say that if a judge says, no, you can't do this in my court. Okay, you want to take the application, take it, I'll give you a bet ruling. You take the application, the judge rules right there.
On the spot? Yes,
on the spot. You know, but when you have a scenario that you allow them to, okay, I need to fight this, I need to fight that, you'll be delaying time, that's when all this would happen. If you add up the call from names of some judges who have stood their ground. We had a scenario of an accused person coming in stretcher to the Federal High Court in Lagos because the judge insisted, in the court in Lagos, the judge insisted that you must come. They brought medical report, said bring him, however he is. Then when he now saw in his eyes the state of the accused person, he now granted some, some adjournment so that they can go and take care of him. So, you see, justice is a three-way traffic. You're talking about the suspect, you're talking about the prosecution, and you're talking about society. So, if you want to reach a conclusion, you must consider these three parties.
And as it turns out, obviously, Douglas Ogbankwa, Esquire, has been able to help us create proper perspective for this week's discussion on the program. That's Law and You for this week. I'm Uyag Mofwegbe. I'll see you next week, Monday. Enjoy the rest of your day.